Hi, welcome everyone, and thank you for joining us today for our first session of our Landlord Learning Series. Before we get started today, I wanted to do a brief introduction of myself and the team that's made today possible. So without any further ado, I'm Jen Moore. I am your moderator for today, and I serve on a committee comprised of both the City of Norfolk Department of Neighborhood Services and Norfolk Redevelopment and Housing Authority staff members. We've teamed up to help promote the Rent Ready Norfolk program as well as the Housing Choice Voucher program. These two programs are essential to helping our committee to tackle our main objective, which is to create more affordable housing stock in Norfolk and throughout Hampton Roads. So I wanted to share with you, on your screen, you'll see a quick list of our committee members comprised of those two organizations I just mentioned. So the Landlord Learning Series is designed to empower landlords like yourselves with information that you need to make informed decisions. We are hosting monthly sessions on a range of topics that impact local landlords. Today's session topic is Virginia Eviction Protections. We hope that you continue to participate in this series as we have another session next month on October 26th. Keep an eye out for an email with those details. And of course, it will continue to be free. The webinar series will take a break in November and December due to the holidays, but we will be back up in January. So stay tuned for those details in a full calendar of sessions. So about today. We'll hear from two presenters. Our first presenter is Ms. Pamela Jones-Watford. Ms. Watford is giving a brief overview of the Housing Choice Voucher program. Some of you may know it as the Section 8 program. From her, we will hear, or after her, we will hear from our main presenter, Mr. Marty Wegbreit on Virginia Eviction Protections. So going over a few housekeeping items before we get started. Let's see here. I ask for you to please hold up on questions until after the presentation today. We'll carve out time to hold a Q&A with both of our speakers at that time. I'll go over those prompts with you on how to submit those questions later. A copy of both presentations will be uploaded in the handout display on your screen. I'll also email the presentations to all attendees just in case. I'm also going to share a survey at the end of the session because we want to hear your feedback on how we can improve the webinar series, and we'd also like to know other educational topics that you would like to learn about. So without any further ado, I'd like to introduce our first speaker, Ms. Pamela Jones-Watford. With her undergraduate and graduate degree in public administration, Pamela began her housing career in 1987 as an eligibility specialist with Suffolk Redevelopment and Housing Authority. In 1992, she began employment with Norfolk Redevelopment and Housing Authority and has held several positions in the Section 8 Housing Choice Voucher Department. She is currently the Director of Housing Choice Voucher Program and has served in the position since 2015. During her years in the housing profession, she's obtained several certifications and licenses for the Housing Choice Voucher Program, project-based vouchers, and RAD programs. Pamela, thanks for joining us today, and we're excited to hear what you have to say. The floor is yours.
All right. Good morning. Good morning, everyone. Hope everyone is well. I'm going to provide to you information briefly on the Housing Choice Voucher Program. The Housing Choice Voucher Program is a program designed to assist low to moderate income persons have decent, safe, and affordable housing. It is a Housing Choice Voucher Program, so voucher holders are allowed to choose and to lease any housing, including single-family homes, townhomes, and apartments. It is affordable as families will only pay between 30% and 40% of their income monthly for their rent plus utilities. Individuals with very low income will receive utility assistance checks monthly to assist them in payment for their actual utilities. With the Housing Choice Voucher Program, it's actually an awesome investment in your property. And with our program, we will assist you in being able to select the right family, your right tenant. Basically, with the Housing Choice Voucher Program, we do determine the individual's eligibility, looking at their citizenship. We also do a criminal background check before persons are allowed on the program, and we do criminal background checks every 3 years or at other times when deemed necessary. So in order to qualify for the program, individuals must not owe any money to housing authorities for past occupancy. They must not be subject to registered sex offenders. They must not have been convicted of any type of drug, criminal activity on the premises of a federal housing program. However, landlords are encouraged to screen for suitability. On the handout that you will receive emailed to you, you will receive information on screening potential tenants. Of course, it's very important to know the screening laws. The screening process is no exception. The laws are in place to protect you, the landlord, as far as the applicants also. Of course, fair housing is very important. So it's very important that you know the laws and also information about the protective classes, race, color, sex, elderliness, sexual orientation, religion, handicap, familiar status, national origin, status of veteran, source of funding, and well as gender identity. Screening tips for the landlords: run a credit check. However, know that our program participants are low-income individuals, so they may have some credit challenges. But if you don't see judgments for not paying their rent, that's a good person to lease to. You may see the medical bills, our utility bills, furniture bills. Again, they are low-income individuals, but we ask you to overlook those challenges that they may have. Verify the applicant's income. Interview the applicant to find out information from them. When do you want to move in? Do you have pets? How long have you lived in your current house? Why are you moving? How many people will be in the unit with you? Do you smoke? And what is your monthly income? So a clean tenant, of course, will have a clean eviction report, fair credit, again, not the best credit, have positive references. It's very, very important that you do check with past landlords. Also that they have steady employment history, Social Security, or other income. So many landlords kind of sometimes go by a gut feeling, but it's important to have a face-to-face interview with the person, and now we're allowed to do everything virtual. So it's just important that you screen and select your tenant. Of course, the housing authority, we do the criminal background checks, but that you screen for suitability and also do an actual home visit. I'd just like to share with you the 5 top reasons that voucher participants make good tenants. They're low turnover. People on the program, on an average, they stay in their homes for at least 5 years or longer. We've had more than 200 of our participants to stay in their home for 15 years. Reliable income. Of course, the housing authority on a monthly basis, the first business day of the month, will make that deposit into your financial institution of the assistance payment. So you don't have to worry about running behind rent or either people having to come into your office. That's reliable income. And also, our tenants are high quality because we do the criminal background checks. We also do free property inspections. We do biannual inspections. We do initial inspections before the families are allowed to move in your property, and also special complaint inspections when requested. Additionally, we will advertise your property when you have vacancies. So we consider it an actual collaboration with the landlords. We have a partnership. The Department of HUD, which funds the programs and make the regulations, you, the owner with the awesome property, within the city of Norfolk that will lease to our voucher holders. The housing authority, we will administer the program, issue the payment monthly, do the inspections, and also review the family's income, and then the family who will have the voucher and also lease your property. So we are ready to get in partnership with you. We would like to make sure housing is available and affordable in the city of Norfolk. Due to new regulations with the source of funds, the Housing Authority, we expedite all cases when families are to move in. Based on the actual regulations, we have to review requests for tenancy approval forms and also have the unit inspected within 15 days. So we work extremely hard to ensure that we will process your tenant for your unit in the expeditious time. When you submit lease to the Housing Authority, I'm not going to just go into everything that has to be on the lease. One thing specifically that sometimes landlords have issues with is actually the utilities within the lease. The utilities must be specified. Who is responsible for paying the water bill? Who's responsible for paying the gas bill? Who's responsible for paying the sanitation, the trash bill? Who's responsible for the heating costs, whether it's gas or electric? And also the appliances that's in the property, the range and the refrigerators provided by the owner or either the landlord. The Housing Authority will review every lease to ensure that it is complete with all of HUD requirements and also housing fair laws. Within the Housing Authority Housing Choice Voucher Program, landlords are not allowed to lease to relatives unless it is for a reasonable accommodation for a disabled individual. With the Housing Choice Voucher Program, we desire to approve the amount of rent that owners desire to charge. We do a rent reasonableness study on all new move-ins and also whenever owners request a rent increase. So we do that by looking at 9 indicators, similar to an appraisal, just to make sure that we are leasing properties with a fair amount of rent. We do compare the rent that you, the owner, desires to lease your property for with comparable rentals that are on the open market. So we do that comparison for you, and also we try our best to also come within lines as to the amount the owner desires to lease their property for. Landlord rules and roles on the program. Of course, you get to select the individual you desire to lease to in your screening process. You enter into a lease with the family. So the program is mirrored just after rentals on the open market. You have the lease, you enforce your lease with the family. You comply also with the terms of the HAP contract. The Housing Assistance Payment Contract is a contract that you will sign with the Norfolk Redevelopment and Housing Authority. And that contract will remain intact as long as the family occupies the unit and also as long as the unit continues to meet HUD housing quality standards. As the landlord, if the family has a rental portion, you do collect it. You pay for any owner supplied utilities as well. Perform normal wear and tear, comply with equal opportunity and fair housing requirements. Anytime you have changes in your address and also your financial institution, so please report that to Norfolk Housing Authority immediately. And also we have an awesome free landlord portal that you can access information about inspections, about payments 24/7 at any time. So our tenant roles and obligations, of course, they have to actually comply to every term of your lease. Just as on the open market, when enforcing your lease, our Housing Choice Voucher holders have to comply with those terms. They have to pay their rent on time. They have to allow the unit to be inspected even by you. If you have in your lease that you will inspect the property every month or every other month, they have to allow you to inspect it as well. They also have to notify the housing authority anytime that there are changes in their income or household composition. You as the landlord, you do have a right to evict voucher participants when they violate their lease. We do ask that you just please always notify the housing authority at any time that you evict families. As I stated before, we do inspections, and we're going to have a session later on our inspections, but we do the biennial inspections every other year to ensure that the unit continues to meet the inspection requirements through HUD housing quality standards. If you see, I have inspection pass, so we know that all of your inspections will pass. We are sure that you, because you want to protect your investment, our inspections give you even an opportunity to look at your unit, because if you lease the individuals on the open market, sometimes they may be excellent payers. So you never have reason to go to their unit because they pay you in advance. They either make a deposit or mail you a check. They never complain about any issues at the unit, so you never go to the unit. But they move out years later. Oh no, they have destroyed your property. Even after a year, this could happen when you lease the individuals on the market, but not on the Housing Choice Voucher Program. And that's why I say it is an awesome investment in your property, keeping your property value up as you want to ensure that the unit continues to pass our inspection. There are some items that sometimes fail, but they aren't costly. You can just get right in. Anytime we do an inspection, if deficiencies are found, we will supply you with a list of the deficiencies and also give you time within 30 days to correct the deficiencies. And as long as the unit passes that second inspection, you are good to go. We do advertise your property. We have a referral listing that we will advertise your property freely. We update our listing every Friday. Our contact for our unit availability listing is ipointer@nrha.us. She is our landlord liaison who will work with you as the landlord to ensure that your time renting your property on the Housing Choice Voucher Program is smooth. So NRHA, we want to help you to lease your property. Voucher holders make good tenants. So we want your units to stay rented while offering our voucher holders units. Thank you.
Perfect. Thank you, Pamela, for that excellent information, that wonderful presentation. And just a reminder for our attendees today, we'll have a Q&A session at the end of the program, so hang tight if you have any questions for Pamela. I'd like to introduce our next speaker, Mr. Marty Wegbreit, who will discuss updates on Virginia Eviction Protections. A little bit about Marty. Martin Wegbreit holds a law degree from the University of Michigan Law School and is the Director of Litigation at Central Virginia Legal Aid Society in Richmond, Virginia, where he has been employed for the past 16 years and has been a legal aid attorney for 43 years. Currently, he is a member of the City of Richmond's Affordable Housing Trust Fund Oversight Board, City of Richmond's Eviction Task Force, the Steering Committee of the Campaign to Reduce Evictions, the Legal Advisory Board of Housing Opportunities Made Equal, and the Virginia State Bar Standing Committee on Access to Legal Services. In his spare time, Marty makes time for groups like ours, bringing valuable information to help local landlords. So thank you, Marty, for being here today to speak on such a timely topic. Marty, I'm going to go ahead and make you the presenter, and you should be good to go.
Okay, thank you very much. Let me get my slideshow up and running. And hopefully you all are seeing update on eviction protections version September 2021.
We do see it, Marty.
Okay, great. So thank you all for attending. And what I'd like to start with is to say that over the past a little over 3 years, Virginia has gone from being a national leader in evictions to a national leader in eviction protections. And the next 45 minutes or so, we'll learn exactly how that happened. As you may know, the CDC eviction protections ended the end of August due to the US Supreme Court decision. However, this decision does not affect the state eviction protections, which as of August the 10th had been restored, clarified, and strengthened. These eviction protections were in effect with the prior state budget from January through June. They lapsed for a little more than a month, and then they were reinstated on August the 10th. What this allows is for landlords to get paid in full, to get tenants stably housed, and to lessen the spread of COVID-19, which is the purpose behind all of these eviction protections. And the good news here is that Virginia is the best rent relief program in the country, and we've spent a higher percentage of our funds than any other state in the country, and we'll talk about that a little bit later on. Well, let's first talk about the non-payment notices that landlords are required to give if a tenant is behind in rent. All landlords, no matter what size, have to provide a 14-day non-payment notice. That is an increase from the prior 5-day non-payment notice. Moreover, a landlord who has more than 4 rental units must, in that 14-day non-payment notice, offer a payment plan to any tenant late on rent. And this also was a change from when such plans were not required to be offered in the past. Now, only one plan needs to be offered every lease term, and the plan has to pay off the rent due in equal installments over the next 6 months or whatever term remains in the lease, whichever is sooner. Both of these requirements will last through June of 2022. Now, in the state budget protections, as of August 10th, the budget protections, as I mentioned, were restored, clarified, and strengthened. So as of that date and continuing through June the 30th of 2022, the landlord may take no action to get possession or evict a tenant for non-payment of rent. That means filing the summons for unlawful detainer, the eviction lawsuit, or going to court on it, or seeking the judgment of possession, or seeking the writ of eviction, unless the landlord has given that 14-day non-payment notice that has to state the precise amount due and inform the tenant about the rent relief program. During that 14-day period, the landlord must apply for rent relief on the tenant's behalf, and unless the tenant has already applied for rent relief or the tenant pays in full or enters a payment plan. Some of the earlier notices, particularly from the Virginia Apartment Management Association, VAMA, had in the 14-day notice that the tenant had to affirmatively ask the landlord to apply on the tenant's behalf. That was wrong, and VAMA has corrected that. So now, in all cases, landlords have to apply for rent relief during the 14-day period unless the tenant affirmatively tells the landlord, no, don't bother, I've already applied myself. Moreover, the budget protections specifically state that landlords must cooperate with rent relief applications, and they must provide all information, including the state W-9 form. Tenants also have to cooperate, and we'll talk about that right now. Once that application has been made for rent relief, the landlord may not take any action to get possession. You can't file the unlawful detainer or do anything additional unless one of basically 5 things is true. The tenant is found not eligible for rent relief, or the tenant refuses to cooperate, or rent relief is not approved in writing within 45 days of a completed application. And this was clarified because that 45-day clock does not start until all of the documentation is in, and there's only 5 pieces of paper, and we'll talk about that shortly. If there's a subsequent second application, then the 45-day clock shortens to a 14-day clock, again, starting with a completed application. Or the final reason that a landlord could proceed is if RRP runs out of money. But as we'll talk about shortly, rent relief now has at least $600 million of unspent money, and that will fund the program well into 2022, probably at least through June of 2022. Now, if a tenant does enter that payment plan that I talked about earlier, the landlord may not take any action to get possession unless the tenant does not follow the payment plan. Now, if you got a judgment of possession before the date that these budget protections took effect, August the 10th, that judgment of possession remains in effect, but you still cannot get the writ of eviction or get the sheriff to actually evict the tenant unless all of these requirements that I just talked about are followed. And that was what the General Assembly put in paragraph 16E of the budget resolution. So even if you've got a judgment of possession, if you've not given the 14-day notice, if you've not applied for rent relief on the tenant's behalf, you have to do that, because the General Assembly really believes that no tenant should be evicted in Virginia for non-payment of rent until rent relief has been given an opportunity to make the landlord whole, keep the tenant stably housed, and reduce the spread of COVID-19. There's a lot of money involved here. It came in two separate federal packages. One was from December of 2020, and Virginia got $524 million. The second came in March 2021. That was part of the American Rescue Plan Act, or ARPA, and Virginia's share was $450 million. In addition, in 2020, there was $160 million of state money that went into the rent relief program. All told, this is $1.1 billion of rent relief. This is unprecedented. We have never seen this much money available to keep landlords whole and keep tenants stably housed, so we should all take advantage of it. The basic eligibility requirements are very simple. The household income has to be at or below 80% of the area median income. This includes the overwhelming majority of tenants behind in rent. The rent has to be at or below 150% of fair market rent. And again, the vast majority of tenants meet this requirement. Finally, the Department of Housing and Community Development, which administers the program, requires that the tenant either have a loss of income or an increase in expenses somehow due to COVID-19, but they have a very broad definition that basically anything that happened to the tenant household that would reduce their income or increase their expenses makes them qualify. So here are some examples of loss of income due to COVID-19. A layoff, a close of a job, a reduction in hours of work, staying home to care for children, losing some child or spousal support, not being able to work due to COVID-19, et cetera, et cetera. Similarly, anything that can be tied to COVID-19 that caused an increase in expenses, childcare, medical care, food costs, utility costs. Goodness, children had to stay home for a lot of virtual learning. So that may have increased the household's electric bill or heating bill or cooling bill. There could have been a need to have increased broadband expense or just buy a new computer. Anything that can be tied to COVID-19 as a loss of income or an increase in expenses makes the household eligible. Now, income eligibility is fairly straightforward. The tenant can complete a self-attestation, or if they receive any of these benefits and the household is less than 4, they automatically qualify. They're getting unemployment compensation, temporary assistance for needy families, supplemental nutrition assistance program, or food stamp benefits, women, infants, and children, or the low-income heating and energy assistance program. Any of those will qualify the household automatically. In addition, this supporting income documentation is not required for those small households, less than 4 people, if they reside in one of 500 zip codes. You can find the list of 500 zip codes at the URL that's on the PowerPoint slide. But I went through it and I found all of the zip codes in the Hampton Roads area. You can see that I believe there's 37 of them. And so if your tenant resides in any of these zip codes, then the supporting income documentation is not required if they're 1, 2, or 3 in the household. some asset verification is required, but only for those households that are above 50% area median income, between 50% AMI and 80% AMI. As I mentioned earlier, there's only 5 pieces of paper that are required for a completed rent relief program application. There has to be a written rental agreement, which means a valid lease signed by both parties, or some other document signed by both parties and dated that shows that there is a rental agreement. It has to simply have the tenant and landlord's names, how much the monthly rent is, what's included in the monthly rent, and the term of the lease. When did it start? When did it end? Or is it a month-to-month lease? The second thing required is the tenant landlord ledger, showing how much is owed as of the date the ledger is completed, because that's how much the rent relief program could very well pay. The third, as I mentioned, is income documentation from the tenant, if that is required. The fourth is the landlord's Virginia, not the federal, but the Virginia W-9. And again, now it's part of the state budget bill that requires the landlord to cooperate and to provide that. And lastly, both the landlord and the tenant have to sign the agreement. It's just 5 pieces of paper to get a federal benefit that will put thousands of dollars in the landlord's bank account and keep the tenant stably housed at the same time. So how do people apply? Well, there are 2 doors, 2 portals for one program. Tenants apply through the Department of Housing and Community Development, and you can see the URL there. In addition, tenants can allow third parties to apply on their behalf through the tenant portal. There are a couple of carve-outs that aren't really going to apply to the Hampton Roads area unless you happen to own property in these areas. Chesterfield County and Fairfax County were both allowed to carve out several $1 million apiece to run their own local programs because they're large jurisdictions, and so those tenants apply through different portals. The second door really is the landlord portal, and they apply through Virginia Housing. You can see the URL there. Both portals have emails where both landlords and tenants can check on the status of an application, whether it's the tenant portal or whether it is the landlord portal. So it's a very open and transparent type of program. Now, the rental assistance gets paid directly to the landlord. It doesn't matter whether it's the landlord applying through the landlord portal or the tenant applying through the tenant portal. Rent arrears can be paid as far back as the month of April 2020. Now, if they're using the December money, which was first appropriated, there's a limit of 15 months assistance. But once DHCD starts using that March money, those ARPA funds, which I believe had happened, then 3 additional months of rent can be paid. So that's a total of 18 months assistance. So if your tenant has been unable to pay rent since April of 2020, well, September is the 18th month. So starting with this month and going all the way back to April of 2020, all of that rent can be paid by the rent relief program. Now, if the 18-month limit has not yet been reached, then let's say maybe 12 months is owed, then the current and up to 3 months future rent can be paid upon application. And that 3 months future rent is automatic. So let's say the tenant owes the current rent and 11 months of arrears, and they apply now, then they could get the 12 months, current and past paid, plus up to 3 months in the future rent paid. And again, that money goes directly to the landlord. It does not go to the tenant. Moreover, until the tenant reaches that 18-month limit, the tenant can always reapply and get an additional 3 months future rent until that 18-month limit is hit. It used to be the case in this program that housing choice voucher holders and other recipients of federally subsidized housing were treated differently. That is no longer the case. And so it does not matter whether your tenant is federally subsidized or not. The rules are the same for both the private market tenants and the publicly assisted tenants. The results of this program have just been spectacular. Over the past a little more than 14 months, over 57,000 tenant households have been served by this program, and you can see the vast majority of them are at or below 30% of area median income. Of course, there are some between 31 and 50, and even a few between 51 and 80%, but the vast majority are below 30% area median income. The total amount dispersed, $410 million. And the average rent payment is a little over $7,000. To give you an idea of just how successful the Virginia Rent Relief Program is, that we have spent roughly 43% of the total funds that were available. Number two, among the other states, is Texas. They spend around 32% of their funds. So we are light years ahead of even number two, let alone states that are down in 10th place, 20th place, 30th place, 40th place. And despite all the success, we still have more than half the money, more than $600 million in unspent funds. And that's enough to pay arrears for at least 84,000 more tenants, in addition to the more than 57,000 tenants that have already benefited. And that's why I continue to say that no tenant in Virginia should be evicted for non-payment of rent until after the last dollar of rent relief money has been spent. There are going to be some future changes now that the ARPA money is being spent. Using the ARPA money, programs can offer assistance directly to tenants if the landlords choose not to participate. But that's not really an option in Virginia for landlords, because the state budget requirement very clearly says landlords must cooperate with the rent relief program, and that includes even providing the landlord's Virginia W-9. The future changes will speed up the process, and it also allows some financial assistance for tenants who want to find new housing, and that can cover things like moving expenses, security deposit, rent, utilities, and even the cost of the transitional stay in a hotel or motel if a family has been displaced. So there's more flexibility for the ARPA money that came in March rather than the initial money that came in December. Landlords are strongly encouraged not to evict tenants for non-payment of rent for 30 to 90 days longer than the period covered by the emergency rental assistance if you get payment. You absolutely positively cannot evict a tenant for non-payment of rent for a period of time that is covered by a rent relief program payment. So, for example, a payment comes through today that covers September as well as October, November, December. You cannot evict that tenant for non-payment of rent for those months that are covered. And I will just tell you very confidentially, the Attorney General's office in Virginia is looking into landlords who are violating this, and they consider this to be a fraud against the Taxpayers Act violation. So you don't want to be on the wrong end of that lawsuit or that claim by the Attorney General's office. So a word to the wise. Now, again, I stress that this only affects evicting tenants for non-payment of rent. Obviously, if the tenant has a non-rent violation, particularly one that is health or safety related, none of these restrictions apply. Landlords certainly don't have to keep tenants who are not following the lease, who are a threat to health and safety, who are otherwise doing what we call non-rent violations. Those tenants can be evicted through the normal eviction process of going to court. But for non-payment of rent, everything that I say covers, and you've got to follow this process in order to get a judgment possession due to non-payment of rent. If you want more information about the rent relief program, the people who run it, you can see are on the slide here. Santo Gordy is the chief person who administers the program. Elisha Harig Blaine is the sort of second in command. Now, statistics tell us that anywhere between 75 and 95% of all eviction filings in Virginia are due to non-payment of rent. And unfortunately, we're not out of the COVID-19 pandemic yet. And as a result of that, the tenants' confidence that they'll be able to pay rent going forward the next few months is unfortunately low. The US Census does a household pulse survey every month, and they consistently find that 1 in every 4 Virginia tenants have either slight confidence or no confidence in their ability to pay the next month's rent. So that's the bad news. But the good news is, of course, that fact that Virginia's rent relief program not only is one of the best in the country, it is the best in the country. And you don't have to take my word for it. The National Apartment Association several months ago cited Virginia's program as one of the 2 best in the country due to both the very clear eligibility rules and the very simple application process. And you can read the story at the link that's on the slide. So rent relief is really crucial going forward. We're still stuck with the COVID-19 pandemic. We've got the Delta variant and cases, hospitalizations, and even deaths continue to creep up slowly in Virginia. And so that's why this program is just so important, to make sure landlords get paid in full, tenants stay stably housed, and we prevent or slow the spread of COVID-19. Now, I would not advise any landlord to not follow the law because there could be severe consequences for not following the law. And if a landlord doesn't cooperate with rental relief program, either the tenant's application or file their own application and cooperate with that application, and just go ahead and file an eviction lawsuit, then there is a defense that tenants and tenant advocates will use in court against the landlord. And that's called the mitigation of damages rule. And this is a basic common law judge-made rule that says that if you are a party who has not breached a contract and the other party has breached a contract, you have to take reasonable steps to minimize your damages, to mitigate your damages when the other party has breached the contract. And the court can refuse to award any money judgment, any damages that reasonably could have been avoided if you took steps to minimize your damages. And this is very clear law in the Commonwealth of Virginia. There's a 1930 U.S. Virginia Supreme Court case, Hannum versus Douche, which says that this mitigation of damages rule applies in landlord-tenant cases. And moreover, it was put directly into the Virginia Residential Landlord-Tenant Act at 55.11251, which says nothing contained in this section shall diminish the duty of the landlord to mitigate actual damages for breach of the rental agreement. So actually applying for rent relief and doing what is needed to minimize your damages, it's not an option, it's a legal requirement. And this is strengthened by last year's amendment to the Virginia Fair Housing Law that Ms. Jones-Watford talked about briefly. So as of July 1 of last year, Virginia's Fair Housing Law prohibits landlords from refusing to accept rent based upon the source of funds. And so just a brief recap of Fair Housing Law. As Ms. Jones-Watford pointed out, before July the 1st of last year, housing discrimination was banned for 8 very specific reasons: race, color, religion, national origin, gender, which included sexual harassment, familial status, meaning pregnancy or having children, elderliness if you're 55 or older, or disability. Starting July 1 of last year, 4 things were added to the Fair Housing Law prohibiting housing discrimination, and they included source of funds, gender identity, sexual orientation, and veteran status. Now, there is a carve-out, there are 2 carve-outs actually to the Fair Housing Law. These laws don't apply to owners of 4 or fewer rental units, or if you have a 10% or less ownership interest in 4 or more rental units. The carve-out also does not apply if the source of funds, particularly the Housing Choice Voucher Program, is not approved within 15 days of the request to approve the tenancy. As Ms. Jones-Watford pointed out, once the unit has been inspected and a lease has been agreed to by the landlord and tenant, then everything gets submitted to the voucher agency, typically Norfolk Redevelopment and Housing Authority, and then they have to approve the lease packet, and they have 15 days to do that under fair housing. And if the 15-day clock runs, then the landlord can say, I'm not interested in renting under the voucher program. Other than that, and other than the mom and pop small landlord carve out, landlords must accept housing choice vouchers. They are required to do so by law. If you say, I'm not taking vouchers, and you don't fit one of these carve outs, then you're simply violating fair housing. So early on, we saw some landlord organizations try to impose a monthly income to rent ratio as a way of not accepting vouchers. And a monthly income to rent ratio is perfectly legitimate, provided it is based not on the total rent, but on the tenant share of the rent. And so we've got this numerical example, which actually was relied upon by the Virginia Real Estate Board. Let's say the rent for a unit is $1,000. The tenant's income is $800 a month. The tenant pays 30% of that as rent, which is $240. And the voucher pays the remaining $760. In that situation, the tenant's monthly income of the tenant is only 0.8 times the total rent. However, the tenant's monthly income is 3 1/3 times the tenant share of the rent. In fact, that's mathematically true. If the tenant is only paying 30% of their income toward rent, then mathematically their monthly income is going to always be 3 1/3 times the tenant share of the rent. Now, the reason for any monthly income to rent ratio is to assess and minimize the risk. And as Ms. Jones-Watford pointed out, there's almost zero risk rather, of the voucher not paying. That money is just electronically deposited into the landlord's account, the beginning of every month. So there's no reason to have a monthly income to rent ratio based on the total rent. Rather, it should be based on the tenant's share of the rent. And of course, the tenant meets the income to rent ratio. Again, you don't have to take my word for it. You can go to the guidance document from the Virginia Real Estate Board, which you've got the URL there, and read the guidance document yourself. 3 more eviction protections that I want to talk about. The first is obvious to any and all responsible landlords. The landlord may not evict a tenant without following the court eviction process. Lockouts, utility cutoff, self-help evictions are all illegal for all landlords in Virginia. Now, if a landlord does file an eviction lawsuit for non-payment of rent, the tenant has the right to pay everything owed, pay the zero balance on or before the court date, and have the lawsuit dismissed. That's called redemption, or pay and stay. And by zero balance, I mean everything that's owed: the rent, the late fees, the court costs, the reasonable attorney's fees if the landlord has an attorney, everything. If so, the judge has no choice but to dismiss the eviction lawsuit for non-payment of rent. The tenant also has another choice at the court date, which is called a redemption tender. If they are getting assistance from some sort of government or nonprofit agency, but the government or nonprofit agency can't cut the check quite right, then they can appear in court with what's called a redemption tender, which is simply a statement in writing on a government or a nonprofit letterhead that basically says that they will have the redemption amount. At that point, the judge has no choice but to postpone or continue the case for 10 days and let the tenant come back on the 10th day with the entire redemption amount. So that's what we call normal redemption to pay and stay. Assuming, however, the landlord gets the judgment of possession, the tenant has one final chance to pay and stay, and that is the right to pay to a zero balance up to 48 hours before the sheriff's scheduled eviction, and the eviction is canceled. We call this the extended redemption or extended right to pay and stay. And the law changed very recently, July 1 of 2021. Up until then, tenants could use any one of these rights only once in any 12-month period of time. But since July 1, when the law changed, if the tenant is a tenant of a larger landlord, 5 or more units, there is no limit on these rights. They can be used any number of times. And the theory being the landlord has been made whole. The tenant is paid to zero balance. Everything that's owed is paid. And so if the landlord is paid in full, the tenant should be allowed to remain. However, again, there is a carve out for small landlords who have 4 or more units, and their tenants are under the old law. They can use any one of these redemptions, redemption tender, or extended redemption only once in any 12-month period of time. Last important point on redemption is that your termination notice, your non-payment of notice, must have language that explains these rights to the tenant. As mentioned earlier, lockouts, utility cutoffs, self-help evictions are all illegal for all landlords in Virginia. And if that happens, the tenant may file what's called a tenant's petition for relief from unlawful exclusion in the general district court. And they can get a lot of relief under that. They can recover possession, get the utility cut back on. They can ask for the rental unit to be terminated without penalty if that is what they want. They can get actual damages, and they can get reasonable attorney's fees. Moreover, the General Assembly decided to take these very seriously, these illegal lockouts done by a very small number of landlords, but nevertheless a problem landlords. And as of July 1 of this year, the unlawful exclusion petition, that tenant's petition for relief from unlawful exclusion, not only requires an initial court hearing within 5 days, it also requires the judge to award statutory damages of $5,000 against the landlord or 4 months' rent against the landlord, whichever is greater. So you don't want to be the landlord who gets that civil penalty, that civil damage award against them, and as a result, you're not going to do that. The new change in the law that took effect on July the 1st has to do with the Service Members Civil Relief Act, which is very common in the Hampton Roads area. And that's a federal law that basically gives service members protections under federal law, like the ability to terminate a lease early if they have to move and given orders to move. Some landlords, again, a small number, were putting in their leases that the service member was waiving or giving up their rights under the SCRA, which to the General Assembly seemed most unfair. I mean, these are people who are, serving their country, and they shouldn't be asked to give up their rights under federal law. So as of July 1 of 2021, any provision in the lease that waives or gives up rights under the SCRA is void. And in fact, you can take that generally across landlord-tenant law and across leases, that under the Virginia Residential Landlord-Tenant Act, quote, any rental agreement shall not contain provisions that the tenant agrees to waive or forgo rights or remedies under this chapter. So if the tenant has a particular right in the Virginia Residential Landlord-Tenant Act, and the lease says otherwise, the Code of Virginia controls, not the lease. So in conclusion, let me mention that this rent relief program is a huge bonus to landlords and their tenants. Nationwide, the total amount of rent relief is $46.5 billion. And there's no other business, car dealers, credit card company, utility companies, anybody else who has received that much money under these various relief programs due to COVID-19. In fact, the $46.5 billion may be the second largest, I would call it bailout, since the auto manufacturers bailout from the Great Recession in 2009, which was, I believe, around $80 billion. So this is not quite that much, but it's a large sum of money. And in addition, to get the word out to tenants and landlords who may not still be aware of the rent relief program, the Virginia Department of Housing and Community Development awarded $3.5 million to Housing Opportunities Made Equal, or HOME. They in turn have sub-granted that to all 9 of the legal aid programs in Virginia, including your local legal aid program, which is the Legal Aid Society of Eastern Virginia. And every local legal aid office in Virginia, all 35 offices, have what's called a rent relief navigator or facilitator or assister available. They go by different names, but all of them have one person in the office, some have 2, to actually help both landlords and tenants apply for rent relief. So the takeaway I have from all this is not an adversarial relationship. This is a win-win relationship, and tenants and the landlords should apply for rent relief. They should cooperate with each other for rent relief, because this is truly a once-in-a-generation opportunity to come out of this pandemic with increased housing stability and landlords getting paid whole, and hopefully we reduce the spread of COVID-19. So that is the end of my presentation, and I need to, I think you've taken control back from my sharing, and I think I can pass the torch back to our moderator.
All right, thank you, Marty. I'll take the sharing away from you. Let's see here, change presenter to me. Okay, perfect. All right, so, oh, I don't want to show my screen. Okay, so let me just pull up here. Y'all bear with me, doing multitasking is my forte, but virtually it's difficult sometimes. So showing my screen to show you guys, see here, there it is. If you can see contact information for Marty and Pamela. So we are going to go over some questions today for the Q&A, but in case we don't get to you, because we do have a very full house with a great show out of attendees today, if we don't get to your question, I want to share this information on the screen for you guys to follow up. So Marty, thank you for that valuable information. Let's see here. I want to open up the virtual room for questions. So folks, if you have a question, you can raise your hand by hitting the raise the hand icon on your screen, and I will call upon you for you to ask your question, or you can type it into the question box on the screen as well. So I know we already have one question that came in during Pamela's presentation from Shalronda Nelson. And let's see here, Pamela, Shalronda had asked a question. Let me pull that up. And bear with me. Again, being tech savvy is difficult sometimes. Okay, if a special complaint inspection is requested, who sets the time frame for repairs to be completed? Is it the landlord or is it the housing authority?
It will be the housing authority, and it's based on the actual deficiency. If it's an emergency item, there are items that must be corrected within the 24-hour period, such as no electricity to the home, the air conditioners not working during the summertime, the same thing for the heat not working during the wintertime. The unit lacks security, the front door is off, smoke detectors not working properly, the ceiling has fallen in. All of those items are 24 hours. So if there is a complaint inspection and the inspector will go out, the inspector will actually, of course, let the landlord know that we're doing the inspection, and also call the landlord immediately after the inspection. Before we do any complaint inspections, however, the family must put in writing to the landlord the actual deficiency. So a program participant can't just call and request a special inspection. We do verify that that family has actually contacted the landlord, advised the landlord of the complaint, and also given the landlord reasonable time to correct the issue.
All right, thank you, Pamela. Next question is from Al Mateen. I believe this is for Marty. What if the tenant does not agree to participate and work with the landlord with the RMP program?
So if the tenant does not cooperate, then that's one of the 4 or 5 reasons that the landlord can then proceed to an eviction. So the landlord at that point, if the tenant has not cooperated, can file the eviction lawsuit, can go to court, can ask the judge for the judgment of possession, get the writ of eviction from the clerk if they get the judgment, and proceed to schedule the sheriff's eviction. Now, what my advice to landlords would be the same as my advice to tenants. If there is non-cooperation from the other party, document it. In other words, you want to have either letters or emails or texts that are dated, that are very clear and specific as to what you are asking the tenant to do, what you're asking the tenant to provide, and by what date, and in particular, what the consequences would be if the tenant does not provide that documentation by that date. And the tenant does not cooperate. I mean, we always heard the saying, you can lead a horse to water, but you can't make them drink. And so armed with that documentation, I would feel perfectly comfortable if I were representing a landlord to go to court with that documentation. And if I'm representing the tenant and seeing that documentation, I'm going to have a heart-to-heart with my tenant and say, what's the issue here? Why are you not cooperating? Because this really is a win-win. So by no means are you foreclosed from any remedy if the tenant doesn't cooperate. By the contrary, you have every right to take the case to court, provided you can demonstrate that in writing the tenant's lack of cooperation despite their opportunity to do so. What you really don't want, and what I don't want as a tenant, and what you don't want as a landlord, is to end up with a he said, she said type of situation where the landlord is saying tenant wouldn't cooperate and the tenant is saying I would, and everybody's confused, and the judge just throws their hands up and says, I don't know what's going on here. So absolutely give the tenant clear instructions in writing as to what's needed, by what date, and what the consequences will be if it's not provided. And also obviously give them a reasonable period of time. I mean, giving them 24 hours or 48 hours to provide something is probably not going to fly. But you give them a week or 10 days and they don't cooperate. I think that your right to go to court is pretty well established.
Okay, wonderful. Thank you, Marty. I've got a few more questions coming in. I've got a caller by the name of Marcus Head. Marcus, you have your hand raised. I'm going to see if I can call on you. I'm not sure if you've got phone capabilities, but your line is unmuted. Marcus, are you able to state your question? So Marcus, I don't know if I can get your audio working on your end. I'm not seeing it connected, but if you wanted to go ahead and type into the comment box your question, we'll get that addressed. We've got another caller by the name of Cassandra Wright. Cassandra, you've got your hand raised. Your line is unmuted. Do you want to go ahead and state your question? Cassandra Wright? Oh, Cassandra, we can hear you. Did you have a question for us or for Marty?
Huh?
There you are,
Okay,
Cassandra.
can you hear me? Oh, okay, all right.
Hear you.
Suppose a tenant has income has not been affected by the pandemic, but they're still, paying slow or missing payments. What do you do in that sense? I got a twofold question. Right, but for example, if that tenant is the income is just Social Security, that has not been affected, but they're still not paying rent. So what do you do in that case?
So that tenant still could qualify for rent relief if, due to COVID-19, their expenses went up. And I gave a few examples during my presentation of expenses that could have gone up during COVID-19. If they had to stay home more, that would cause their utility bill to go up. Or if they were taking care of their children or grandchildren at home because of virtual learning, they might have had increased expenses there. So don't think of it as just this tenant had fixed income, it didn't change at all, they can't possibly get rent relief. You have to look at the expense side as well. But let's assume that the tenant's income was exactly stable, didn't go up, didn't go down. Their expenses were exactly stable, and for whatever reason, they weren't paying their rent in full and on time. Well, if you're a large landlord, in that 14-day non-payment notice, and by again large landlord, I mean you have 5 or more rental units, you still have to offer that tenant a payment plan to get them to zero balance within 6 months. But if the tenant just does not take up the payment plan and would not qualify for the rent relief program, then the law is the same as it's always been, except of course you had to give a 14-day non-payment notice. Again, the whole point of these state protections is to try to lessen the effects of the COVID-19 pandemic. It's got the reason for the non-payment, whether it's loss of income, whether it's increase in expenses, has to somehow relate to COVID-19. And I think the situation you're talking about is probably very much the exception, not the rule. But those exceptions do exist, and we base public policy not on the exceptions but on the rule. And the rule, we believe, is that most tenants were affected by COVID-19 and have been unable to pay rent in full and on time every month because of that. But for those rare tenants who just haven't been affected by COVID-19 and just are behind, give them the payment plan if they're entitled to it, and otherwise follow your normal procedures after giving the 14-day notice.
Okay,
Wonderful.
thank you.
Cassandra, was that the second part of your two-part question?
Okay, if you have a tenant that is actually, destroying the property, you found out when you finally got in, and we're in court, he has 30 days. I don't know what's going to happen, but if the tenant is actually destroying your property, what cause do you do that?
Right. So again, all of these protections, the 14-day notice, the rent relief program, only applies to evictions for non-payment of rent. For non-rent breaches, again, if it's one that can be fixed, which doesn't sound like what you're describing, but it would be a 21 30-day notice. 21 days to fix the problem. If the problem is fixed in 21 days, the lease continues. If the problem is not fixed in 21 days, the lease terminates. After 30 days, you file your eviction lawsuit on day 31 or beyond. If the problem flat out can't be fixed, then of course you can give a straight 30-day notice. Or if you've given a prior 21-30 for that same problem and that they fixed it once and now it's the second time around, you don't have to give them a 21-30 a second time. You can give them a straight 30-day notice. Now, if it is a intentional or criminal act involving a threat to health or safety, and all of those words are important, intentional or criminal act involving a threat to health or safety, then you can give less than a 30-day notice before filing the eviction lawsuit. You could give a 24-hour notice or a 48-hour notice or a 72-hour notice. But again, it's a really narrow exception to the normal 30-day notice requirement. But to go back to something that Ms. Jones-Watford pointed out, for voucher tenants, there's going to be regular inspections. For private tenants, there aren't regular inspections, but the Virginia Residential Landlord-Tenant Act does allow a landlord the right to reasonably inspect the premises with proper advance notice, which is generally at least 24 hours notice. And the Virginia Residential Landlord-Tenant Act also says that the tenant cannot unreasonably refuse to allow the landlord in once the landlord has given proper advance notice. So as I stressed earlier, documentation is key. Just a phone call saying I want to come tomorrow is not going to cut it. But a letter, an email, a text announcing that reason to come. And I think inspecting the property, certainly quarterly is reasonable, possibly even every other month. More frequently than every month, I think would be a bit unreasonable. Would hopefully guard against you be caught unawares that the tenant is not keeping the property properly. And if you do notice that it's being destroyed, then certainly the notice can be given and the lawsuit can be filed.
Perfect. Thank you, Marty. And thanks for that question. We do have a handful of questions here, so let's try to breeze through them. Question from Jessica Darden. When you say less than 4 of the zip codes not required to provide income documentation, does that mean 4 or 3?
Less than 4 means 1, 2, or 3 in the household. Fewer than 4.
Gotcha. Perfect. Thank you for that clarification. Another question from Almatine. Can I still evict after the lease ends? In parentheses, he emphasized no holdover.
That's an issue that landlords and tenants have been grappling with, not only with the state eviction protections, but also with the CDC eviction protections that no longer exist. If in fact there is absolutely no other reason for the eviction, then the lease is ended and the landlord does not want to renew, then that's acceptable, assuming it's not a Section 8 unit-based lease where the tenancy is an indefinite duration. But if it's private or if it's even a voucher, there's no legal requirement that the landlord renew. The tenancy is not indefinite in effect. But we legally, and I'll just be very upfront about this, believe that if in fact there is rent owed, then we believe that under the mitigation of damages rule, the landlord is actually required to apply for rent relief and to mitigate their damages. I mean, that's a requirement in the Virginia Residential Landlord-Tenant Act. So if the tenant owes hundreds or thousands of dollars and the landlord says, to heck with it, I'm just not going to renew, we're going to come back and we're going to say, we think that's a pretext, Your Honor, and we think the real issue here is non-payment of rent, and we think the landlord should be required to mitigate the damages, and we think the landlord is violating the Virginia Fair Housing Act by refusing to accept a source of funds that's otherwise available. So my big takeaway would be the tenant is in total compliance with the lease, both the non-rent provisions and the rent, and they're certainly up to date on the rent. There's no requirement, absent federally subsidized unit-based housing, that the lease has to be renewed. But if there's any rent owed, I think you're going to you may run into problems with a good tenant advocate.
All right, thank you, Marty. Next question is, on our 14-day notice, it says that we will apply directly to the RRP on their behalf, on the tenant's behalf. How can we do that if they do not cooperate with signatures and information needed to apply?
Well, I think I've alluded to this before. Document it. And I mean, I understand talking with a landlord attorney several months ago, and I think this is still the case, that on the tenant portal, the tenant is allowed to submit a partial application, not every document there. But the landlord application through Virginia Housing, they have to have all of the documents before the Virginia Housing portal will accept it. That's my understanding, talking with a landlord attorney a couple of months ago. I don't know if that's changed, since I don't apply through or my clients obviously don't apply through the landlord portal. But again, the answer I gave before, it's tell your tenant in writing, what's needed, why it's needed, the deadline by which it's needed, and what the consequences will be if it's not provided. And then if you've got that documentation, I think you've got a clear runway to tell the judge, I give the tenant every possibility, every opportunity to work with me, to apply for rent relief, and they wouldn't do it. And if you've got that documentation, I don't think there's any judge in the state that's going to penalize you for something that was beyond your control.
All right, thanks, Marty. Question for Pamela. When the move-in condition report and photos show the property to be in excellent condition and the tenant causes damage, will the voucher program pay or make the tenant pay for the damages? Will the voucher payment be stopped in this case? When the tenant causes damage that would cause the property to fail inspection, will the voucher program pay for the damages when the tenant leaves damages after move out and they are greater than the security deposit?
Okay, so that was several questions. We do not pay for damages, even if it exceeds the actual security deposit. This program is mirrored after rentals on the open market, so the family will have to be sued for any damages that exceed the actual security deposit. If the unit becomes substandard and is tenant related, if it's based on the utilities, the payments will not stop. However, if the unit becomes substandard, the payments will stop. Yes, we will tell the family that they have to pay for those damages. We will work in all means that we have to ensure that that family will make good damage payments. We let families know that if they are evicted from the unit by the landlord due to any lease violation, and of course damages to the unit is a lease violation, that family will lose their voucher assistance. So with that, the family would know, and it would behoove them to pay for any tenant-related damages while they are in the unit.
Perfect, thank you, Pamela. Next question here, and I see some folks have submitted a couple of questions, but I'm just trying to be fair and making sure everyone has an opportunity for a question here. I did have the question if we can make these presentations available, and they are available in the handout section of your screen. If you can't access that, we will be emailing them out to all participants today, probably this afternoon. But another question here for, let's see here. Looks like Pamela, why can't family rent to a Section 8 recipient?
They actually can if it is for a reasonable accommodation for a person that is disabled, but per HUD guidelines, it's actually a conflict of interest to lease to a family member. Of course, this isn't by Norfolk Housing Authority's rule, but this is actually the federal guidelines for the program, that it's a conflict of interest to lease to a relative. But if it is for a reasonable accommodation, the individual is disabled, they would have to complete the forms requesting that accommodation. We would definitely approve it if it is a disabled person needing to lease from a relative.
Perfect, thank you very much, Pamela. Let's see here, I'm just trying to sort through. Let's see here, making sure everyone has a chance here to ask a question. Ms. Tiffany Parker, her question is, can I apply for rent relief program if you have, can I apply for the rent relief program if you have a rent lease with a family member and they are not paying because of the pandemic related to unemployment? Marty, that one's for you.
I mean, if I understand the question, I mean, yes, of course. I mean, the requirements are only that the tenant has had some loss of income due to COVID-19 over the past really 18 months and has had some increase in expenses, again, due to COVID-19 for some amount over the past 18 months. I mean, given COVID-19's widespread impact on virtually everybody, I mean, virtually everybody's had some impact on their finances due to it. And so, yes, you absolutely can and should apply for rent relief on behalf of that tenant.
All right. All right, our next question here. If we evict a resident that has refused the RRP and then owes a large sum, can we then go back and apply for the RRP?
My understanding is no. In other words, the whole point of RRP is to keep tenants stably housed to reduce the spread of COVID-19. Again, that's because that's the whole purpose of this money. It came in 2 COVID-19 relief bills, so it's not just a general grant to make up lost rent. It's a grant to pay rent arrears so that tenants can stay stably housed, and at the same time keep landlords whole and reduce the spread of COVID-19. So if the decision is made to evict a tenant, well, let me put it this way: if the decision is made to evict the tenant for non-payment of rent, and that for some reason goes through, I would think that RRP would not accept that would not pay that application. On the other hand, if the decision were made to evict the tenant for some non-rent breach and they still owed money, I think that would be a different situation. I think RRP would be accepting and pay that application.
All right. Next question for Pamela. Will Norfolk port vouchers from Norfolk to Chesapeake? And who will do the inspections?
Yes, we will port a voucher holder upon their request to Chesapeake. So once they are ported to Chesapeake, the assistance will be administered by the Chesapeake Redevelopment and Housing Authority, who will also conduct the inspection, because the unit that they lease would have to be in the city of Chesapeake.
Okay, very helpful. Thank you for that clarification. Let's see here, another question. These are some long questions, y'all. I'm gonna try to get through all of them. Okay, here we go. And they keep coming in. So let me remind you guys, once we hit 12:30, we may not get to your question. I want you to email either Pamela or Martin. Information is on the screen. Our next question here is, if there is a tenant who has received 18 months of rental assistance, then will they be able to apply and receive assistance for any months from January through June 2022?
The answer is no. I mean, once they've hit that 18 months, that is the end of rent relief assistance. Again, if you're the large landlord, 5 or more units, you do have to offer the payment plan in the 14-day non-payment notice, but that would be a tenant who would fall in the category of simply being ineligible for additional rent relief because they've hit the 18-month limit, which, as I pointed out, if a rent relief is paid back all the way to April of 2020, this month, September 2021, is the 18th month. So if they hit that limit and they can't pay October, November, December into 2022, give them the 14-day notice, which is still a requirement through June, and offer the payment plan if that applies to you. But if they can't enter the payment plan or won't enter the payment plan and they owe and they've hit the 18-month limit, then the courts are open to you.
All right. Thank you, Marty. Another question. And this one has me stumped, and I thought I was following along pretty well. So, question from Michelle: how does the RRR program work for HUD program section 202?
It would be no different. Again, the current and the former versions of the rent relief program, which has been evolving constantly in Virginia, made a distinction between public tenants and private tenants. That distinction is gone. So tenants that receive some form of federal assistance, whether it's public housing tenants, whether it's Section 8 unit-based, whether it's Section 8 tenant-based vouchers, whether it is the older Section 202 program that you're talking about, which is sort of the precursor to the Section 8 unit-based, they're all treated the same. There's no distinction between those.
All right, wonderful. Thank you for that. We've got a couple more questions here. We've got 1, 2, 3, 4 left that I think we will have time to get to. Let's see here. Question for Marty. If a resident owes rent prior to COVID-19 pandemic, does the RRR help pay for that amount or other RRR programs for this?
Our RRP will go back only as far as April 2020. If rent is owed prior to April 2020, that will not be covered by RRP. Perhaps there are other programs that would. If those are available, seek them out under mitigation of damages, but don't try to get it from RRP. That will not fly.
Gotcha. Thank you very much. All right, Marty, another question for you. To your knowledge, how long does the RRP process take to make a payment once the information has been submitted? My concern is, as a landlord, having to pay the mortgage while trying to protect my credit.
Absolutely, and we sympathize with that. I mean, once the completed application is in, RRP has 45 days. That's a month. That's a month and a half. And the vast majority of payments are made within that 45-day period. If the mortgage company is giving you a problem, talk to the servicing department and try to get some type of extension, some type of forbearance, loss mitigation, whatever. All of the mortgage companies have those types of options available. Just ask about them.
All right, awesome, great information. All right, last question. This one again is for Marty. Do I understand you correctly that you have, if I can read this one, this one's a long one. Do I understand you correctly to have said that if the tenant landlord applies for and receives rent assistance, the maximum 18 months that the tenant can get, and then the tenant still fails to pay any rent due, that they may not be evicted until 90 days later?
No, that's not what I said at all. What I'm saying is that landlords are encouraged not to evict for 30 to 90 days after the month for which the last payment was made. So if they paid through, if RRP has paid through September, landlords are encouraged not to evict in October, November, or December, but there's no requirement. Obviously, you can't evict for non-payment in September if September, in fact, was paid. But once the tenants have hit that 18-month limit, and some are going to hit that limit starting next month, others certainly later in the year and into 2022. Once they've hit the 18-month limit, then other than the offer of the payment plan to catch up the arrears and get to zero balance in 6 months, that's really the protection that will be left, because obviously the government can't pay people's rent indefinitely. $46.5 billion is a lot of money, and that's going to get us through the pandemic. But hopefully in the post-pandemic world, things will go back to normal and most tenants will be paying their rent in full on time every month. If they don't, and they hit the 18-month limit, then again, the courts are open to you.
Wonderful. Thank you for that clarification, Marty. All right, that concludes all of our questions today. Thank you for folks tuning in. Those were some really good questions. I'm glad we were able to provide that clarity. It looks like we're at the end of our time. So like I said before, for those who have additional questions or if your question wasn't addressed, go ahead and just email Marty or Pamela directly. Their information is provided in the handout. We're also asking for you to take a quick moment to complete our post-event survey and give us some feedback about topics that you want to hear in the series, as well as the session today. So I'm going to go ahead and pop that survey into the chat box on your screen. So I hope you found today's program helpful. We will be back again on October 26th with our next session, so keep an eye out for that email. But that's a wrap for us. I want to thank Marty and Pamela for taking the time today to sit down with us. We really appreciate it. If my memory serves me correctly, the committee will be sending you a little thank you in the mail, so keep an eye out for that. So again, everyone, thanks for joining us, and have a great rest of the day.
You're welcome. Bye-bye.